case briefs, and so much more. LSData's got what you're looking for.
In 1968, the New Jersey Superior Court Law Division heard the case of Zabriskie Chevrolet Inc. v. Smith, which revolved around a seller's responsibility in fixing a broken vehicle without replacing parts that weren't part of the original agreement. The case involved two disputes between buyers and sellers of defective goods. In the first dispute, a buyer purchased a new car from a seller and experienced mechanical failure almost immediately after leaving the showroom. The buyer canceled the sale and stopped payment on their check. The seller sued for the outstanding balance of the purchase price and incidental damages, while the buyer counterclaimed for the return of their deposit and incidental damages. The court found that the warranties in the sales contract were ineffective, and the manufacturer was responsible for social justice demands. In the second dispute, a buyer purchased a 1966 Chevrolet automobile, paid a deposit, and tendered a check for the remaining balance. After leaving the showroom, the buyer experienced the car stalling and becoming nearly inoperable due to a defective transmission. The buyer demanded a refund from the seller, but the seller claimed they had properly rejected the defective car under the code. The court determined that the seller was still liable for the substantially defective product, despite the disclaimer of warranties. The court concluded that the defendant was entitled to judgment in the main case and on the counterclaim. The seller's attempt to replace the defective transmission with one from another car was deemed ineffective. The court ruled in favor of the defendant, awarding them a refund of the purchase price and requiring the vehicle title to be transferred upon their demand. The defendant was also awarded judgment against the plaintiff for the $124 deposit.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.